On intellectual property or IP. My name is Talia and I'm an intellectual property lawyer at LegalVision. I help all kinds of businesses, from startups to established businesses, to develop and protect their intellectual property. So this webinar is part one of a two-part series. In this first part, we will discuss the basics of intellectual property, and then following on in part two, we will discuss why your business should protect its IP. So who is LegalVision? LegalVision is a tech-driven full-service law firm that uses technology to deliver a faster and more cost-effective client experience. We were recently named the fastest-growing law firm in the Asia Pacific by the Financial Times. We are a dedicated commercial law firm with expertise in intellectual property, general commercial law, disputes, corporate law, and franchising. This means that we can help businesses with a wide range of their legal needs, whether that means applying to register a trademark or raising capital. So today in part one, we're going to look at intellectual property in Australia. We'll discuss what it is and how you can protect it. So specifically, we'll look at what intellectual property actually is and what sorts of things are considered intellectual property, including specifically copyright, patents, trade secrets, and trademarks. And we'll also look at a famous trademark case to highlight the importance of understanding your IP. Once we've developed a good understanding of what intellectual property is and why it matters, we'll then go in part two to discuss how you can protect your intellectual property and why you want to protect it. So intellectual property, or IP, is an umbrella term for the creation of your mind that can be legally owned or commercially exploited. IP can be your creation or a productive new idea. Generally, though, it is something new or original. However, it's not always easy to work out if your idea is actually original or not. IP can also be understood as the elements of your business that differentiate you from your competitors. This includes things like your trade secrets, your logos, and your slogans. Almost every single business has some form of IP that can and should be protected. It's important to note here that it's up to you as the holder of IP rights to enforce your rights if someone infringes on them. That's because there is no IP police force as such, but there are many legal processes and mechanisms in place to help you protect your rights. IP also doesn't necessarily have to be something that business owners develop. More often, employees, contractors, or consultants are the ones who are actually developing IP. With the right contracts in place, you can make sure that any IP that's developed by employees, contractors, or consultants you own. In the second webinar, we will go into some more detail about how to structure this appropriate IP ownership. Although it can be an invaluable asset, many business owners fail to recognise the value in their IP. So it's extremely important to understand what IP your business actually has, how to recognise the value in that IP, and then how to seek out the best ways to protect those assets. From here, let's take a look at what forms of IP exist, so you can then recognise what IP your business may have and, in turn, recognise that value in the IP. So with copyright, it's one of the most recognisable forms of IP. Copyright is the exclusive legal protection given to creators of specific created works. These can be things like paintings, screenplays, song lyrics, digital recordings, and articles. These types of created works are all given automatic copyright protection. Copyright exists the moment a piece of work is created, and creators do not need to apply for any specific protection. Copyright means that the creator can decide how the specific creative works can be used and then give other people permission to use the works for a fee. You don't need to formally register copyright, which means that protection begins from the moment the work is actually created. For example, as soon as you've produced a website article for your business, it is protected by copyright. Many copyright owners will signify their copyright by including the C symbol on their works, although you still have copyright protection even if you don't use that symbol. Copyright is a valuable IP right, but many businesses forget about it when considering their overall IP assets. So a trade secret, put quite simply, is exclusive knowledge. If you are the rights holder, it is your responsibility to protect this knowledge. A trade secret can be any specific confidential information, such as a secret formula, processes, or methods used in production. There are certain methods you can use to protect trade secrets, and one of the most common ways of doing that is attempting to protect trade secrets through the use of a confidentiality agreement. A A confidentiality agreement is essentially an agreement between parties that all parties will keep the information outlined in the agreement secret. Now, although you specifically can't register a trade secret and you cannot stop someone from independently inventing the same thing as you, as long as they've not copied your idea directly from you. However, many businesses have been successful at keeping trade secrets confidential. And some of the most famous are easily recognizable, like the Coca-Cola recipe and the Colonel Sanders 11 secret herbs and spices. These are not protected by a patent, which means that the businesses have not been required to disclose their recipe and have been able to maintain their confidentiality. More often, trade secret rights are enforced through breaches of confidentiality or employment agreements rather than specific infringement proceedings. If you have invented something and you would like to secure specific protection over that invention, then you may wish to apply for a patent. The next IP rights we will discuss are all rights that require specific registration through IP Australia. IP Australia is the government body that administers patents, designs, plant breeders' rights and trademarks. Although we're not going to go in specific detail about plant breeders' rights, we'll discuss patents, designs and trademarks. So we hear a lot about patent in the media and TV shows, but what exactly is a patent? A patent is a registrable intellectual property right that specifically protects inventions or new processes. A patent can protect a device, substance, method or process that is new, inventive and innovative. In Australia, a registered patent gives you the exclusive rights to exploit your invention for up to 20 years. As the patent right holder, you have the exclusive use of that patent. You can also choose to further commercialise it by licensing the patent to others if you wish. And depending on which markets you plan to launch your invention or process into, you can also apply to protect your invention or process internationally. This is important to note, as an Australian patent application will only provide you with protection in Australia. Patenting can also be very expensive, so you should weigh up the patent application and maintenance costs against the commercial advantages provided by patent registration. Lastly, it's really important to be clear that you cannot patent an idea. So let's move on to another registrable right, the design. So a design is a registrable intellectual property right for something with commercial or industrial use, which can be registered and subsequently used, licensed or sold. A design is generally something that makes the overall appearance of a product distinctive. Designs can therefore be shapes, patterns, arrangements or ornamentation. When the design is applied to a product, it gives the product a unique appearance. It can therefore be protected through IP Australia. The aim of registering a design is to secure the rights to exploit the design commercially. You can hold a design registration for up to 10 years in Australia, giving you the chance to commercialise the design. If you have developed a unique design for your product, a design registration may be a good idea. Design registrations are often used by those who cannot patent their development as a way of securing a limited amount of protection. When thinking about a patent or design application, you should be wary of too much publicity around your invention or design. You need to make sure you don't publish the details of your invention or process or design until you have actually secured registered rights and ownership. If you publish this information about your potential patent or design before the rights have been granted, you may actually lose the chance to claim exclusive rights. So far we've discussed patents, designs and trade secrets. Let's move on to the most well-known IP right, the trademark. Along with copyright, most well-known form of IP is the trademark. A trademark is a registered IP right, and examples can be a business name, a slogan, a logo, pictures, aspects of packaging, sounds, and even smells. So to apply for a trademark, you must first make an application through IP Australia. IP Australia will assess your application and provide an indication of whether this mark is able to be registered. The best trademarks are often marks which are unique and also don't have a clear meaning in the industry in which they're used. When in the development stages of your business name or slogan, it can help to think about some of the best trademarks. These are often the ones which have an are easy recognizable and do not have a particular meaning in the industry they operate in. So for example, Apple, there's no particular meaning in relation to technology for this name. Kleenex, Cadbury, Penfolds and Vegemite. Trademarks are the most commonly registered IP right. They are one of the first considerations that many startup founders make. And if you have developed a unique business name that differentiates you from your competitors and identifies your business to your customers, it's important to apply for a trademark protection. Sometimes business names will not meet the general criteria for protection, and so in this case, you may wish to consider applying to register a key slogan or logo instead. When you first file a trademark application, it will be examined against set criteria by a particular IP examiner. When IP Australia considers your trademark application, it will look at two key things. First, is the potential mark likely to be confused for another mark? For example, it would be very difficult to register the name Jacob's River in Class 33 for wine, as that would most likely cause confusion for the general public between your new product and the existing product sold under the registered trademark Jacob's Creek. When applying for a trademark, it's also important to check whether any marks exist that may be too similar to your proposed trademark. A trademark lawyer can actually help you perform thorough searches in this regard. So second is the potential mark too descriptive of the goods and services that you provide. For example, if your business name is Sydney's Accounting Services and you provide accounting services, you may actually be unable to register your mark in Class 35 for accounting, as your name is simply descriptive of the goods and services you're providing. When applying for a trademark, it is often best to not directly describe the goods and services you'll be using the trademark for. Although this may all seem quite daunting, there are many strategies to either avoid or overcome the issues. It's also worth persisting with the trademark application process, even if you do face issues, because once registered, your trademark is protected for at least 10 years, and you can then enforce your rights against others who may infringe on your mark. The case study. You may already be aware of one of the most famous trademark disputes in Australia, the legal battle Burger King faced when it first launched in Australia in 1971. At the time, there was already a restaurant called Burger King operating in Adelaide. The problem for the new king? The restaurateur in Adelaide held the trademark to Burger King, and therefore Burger King wasn't able to secure the right to the mark. This actually led to the redevelopment of the brand when launching into the Australian market, and it's now the only market in the world with different branding. Today, Australians know Burger King as Hungry Jack's. Although Hungry Jack's has ultimately been successful in Australia, the costs of rebranding and the legal dispute were substantial. What does this tell us about trademark protection? Most importantly, it tells us that it is best to register your trademark early and widely. If you are thinking of launching into an overseas market, you should consider your options for protection early. Trying to protect an unregistered trademark in the future can be extremely expensive, and rebranding may not be an option for you. Here at LegalVision, we regularly provide clients with guidance as to the likely success of their applications, and also work with them to develop strategies to secure broad trademark protection. So now we've covered which IP rights exist and how your business might have more than one intellectual property right which is actually worth protecting. The next question to consider then is how to protect these intellectual property rights. We'll look at the protection of your intellectual property and answer this question in part 2 of the webinar. So to sum up, in this webinar, we looked into the many forms of IP that exist, from straightforward rights like copyright through to the more complex areas of trademarks and patents. We spoke about the most commonly recognised IP right, the trademark, and how the best trademarks are unique and do not describe particular goods or services that you may provide. The best branding is something which stands out from your competitors. Nearly every single business will have some form of IP which is valuable. It is important to recognise how valuable these IP assets are for your business. The next step is to understand how you can best protect these assets. In part 2, we will look closely at how you can protect your IP assets. LegalVision can advise you on all aspects of your intellectual property, whether you already have a suite of IP or are just now looking into what IP you might have. Our experienced intellectual property team can discuss your options and provide you with the best strategies moving forward. If you would like to understand more about what IP assets you have, or if you're ready to move forward with protection, you should contact LegalVision's team of experienced intellectual property lawyers to get started today. Thank you for your time, and I look forward to seeing you in the next webinar on intellectual property protection.